We appreciate all of the guests who have appeared on our show and sincerely thank them for providing you, our audience, with useful information. However, the advice our guests provide is theirs, and we encourage you to seek out a professional if you have specific questions about any topic we cover on the Crushing Debt podcast. On this week's episode of the Crushing Debt podcast, attorney Christie Arkovich.
Welcome to the Crushing Debt Podcast with your host, Florida attorney 𝘾𝙝𝙧𝙞𝙨, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to the podcast. My name is 𝘾𝙝𝙧𝙞𝙨, and like I said in the intro, not only do I have a guest, but I have a returning guest, attorney Christie Arkovich. Welcome, Christie.
Thank you.
Christie and I last talked on the podcast in episode 50 all about student loan issues and how you could use bankruptcy to eliminate student loans in some circumstances and some other non-bankruptcy alternatives for getting rid of student loans. But I wanted to have Christie back. She did a great time. Her episode, episode 50, is one of my highest episodes, one of my highest download episodes of all time. So obviously you all like the content. So I wanted to have Christie back to talk again about student loans. So I wanted to talk about, and I know you wanted to talk about, the public service loan forgiveness programs that are available. So why don't you explain what those are and what the different programs are?
Sure. We're seeing a lot of success in our student loan practice. Private loans, we're getting very low settlements in place. Federal loans, we're getting good income base, usually $700 less per month, and shorter time frames for the forgiveness to kick in. But we are seeing some pitfalls, and one of the pitfalls that I wanted to raise awareness about, and we have actually filed several class action suits against Navient and Great Lakes this month, is on public service loan forgiveness. Basically, this is a law that was passed in 2007 by President Bush, and it essentially encouraged folks to go to school, get higher education degrees, and then work public service. And in order to do that, people needed to have the promise of having an income-based payment as well as debt forgiveness at the end of 10 years so that they could actually afford to work in the public arena. And so the program's good. The program's legitimate. It's out there. It is congressionally passed. The problem, though, that we see is, like most governmental programs, it's complicated. And so we've got servicers out there that are telling people that, yes, you're on the program. All you have to do is make your 120 monthly payments. And at the end of 10 years, file your application. And that's it. There's nothing else you need to do. And so these clients of ours that we see repeatedly will come in and say, oh, I'm on public service, all is good, I will check, and it will turn out that they're not even day one into the program. And this is the first time that they're learning that there's even a problem. And
why are they not, if they believe they're in the program, why are they not in the program?
Well, one of the biggest reasons that we find, and this is the basis for our class actions against Navient and Great Lakes, is that they simply have the wrong loan type. The public service loan forgiveness is only eligible for what's called direct loans. And the older FFEL program, which is Family Federal, or I think it's Federal Family Education Loans, it was around at the same time as direct loans in the 60s and 70s and 80s, and 80% of the loans were FFEL back then. Only 20% were direct. And the FFEL program was eliminated in 2010. The problem is that there's an awful lot of FFEL loans that are still out there. Most of them are that, in fact. And FFEL loans aren't eligible for this relief under public service loan forgiveness. And so it's a simple matter of having the wrong loan type. And unfortunately, the statements that people will get in the mail or online from these servicers will say, all right, you have a Stafford loan, you have a subsidized loan, you have a Perkins loan, but it won't say whether they're FFEL or direct. You have to go on to something called the National Student Loan Database, nsLDS.org.edu. You have to go on there to actually see whether your loans are FFEL or direct. And if they're FFEL, you need to change them because you think you're in a program that you can't possibly be in. And it's not hard to change them. All you do is consolidate, which is basically a refinance to the newer direct loans.
So people are on the public service loan forgiveness or believe they're on the public service loan forgiveness program. They really have a FFEL loan. And so when they call their servicer, when they call Navient or whoever, and they say, okay, now it's time to forgive the loan, and then Navient comes back and says, well, we can't because you weren't in the right loan program.
Exactly.
So is there anything that would tip off the student loan borrower at the front end? In other words, so let's say they were making $250 under the old loans, under the FFEL program, and then they believe that Navient has them switch to the Public Service Loan Forgiveness Program, they're still paying that $250 a month, or does that time period of payments prior to the forgiveness of the loan, does their payment amount change at all? Is there anything that, other than maybe contacting you or researching it on the internet, is there anything that tells them you were on a FFEL program loan and now you're not, or you've switched it, or you haven't yet switched it?
Sure. Basically, there's an easy way to tell. There's a certification form, and so you can mail that in, and it basically will tell the Department of Ed, here's the loans that I have, and here's the employer I work for, here's how many hours I work, just to make sure that you do qualify for public service. And these certification forms, they are not legal in nature. In other words, they're not granting or denying relief. They're simply kind of taking a measurement midway. And so you can send that form in, and if that form comes back, if you have the wrong loan type, one of the first boxes for the denial will say that you have a FFEL loan as opposed to direct. So the certification form is an easy way to check. Those are available online. You can send them in, and that will also check to make sure your employer is correct, because it is only something eligible for government employees like local, state, federal, or 501c3. Some of the nonprofits are excluded if they lobby and so forth, some of the other subsections, so it's a 501c3 are eligible. And you can fill out the form and send that in. Secondly, you can contact a student loan attorney. There aren't a lot of us, but there is getting more and more every day.
Right.
And then you can also look at that National Student Loan Database site to see if you have FFEL versus direct loans. But one of the other things is that you have to be making a payment on an income-based plan. And there's about a half dozen income-based plans, and they're not all the same. They're very different in terms of whether they apply and what the payments are and how it's calculated. But any of them will work. It has to be income-based. Those are the ones where you renew each year. If you're on an extended or graduated loan where your loan payment is lower but it's not redone every year, those don't qualify. So that's a second problem that we're seeing with public service loan forgiveness. And so the purposes of our class action is not necessarily to correct that particular client going forward. What we do for that client is we change their loan types and we make sure they're on track for the next 10 years. But we can't go back and recover those last few years without filing a lawsuit, and that's what the purpose of our class action is for. Perhaps we'll be able to convince a court that our client has been damaged and that the servicer should have known that they had the wrong loan type when they were on the phone with this client, and they should have advised them on what to do, and certainly not told them that they're in a program that they're really not in.
So the purpose of the lawsuit is to get the student loan borrowers some money back, or is it possible to claw it back and say, okay, we've been paying for the last 6 years, now we filed this class action lawsuit, and one of the remedies that we're seeking is we only want to pay another 4 years before we qualify under the program, or is it a lawsuit to compensate for damages, or both?
It could be both. Basically, we're looking to obtain relief for the lost years. A lot of our clients are 4, 5, and 6, 8 years into a program that they're not even day one into. So all the payments they've made towards the loan that they now have to redo for the next 10 years, that would be the damage that they would be entitled to. We're arguing essentially that it's a breach of fiduciary duty. These lenders are given the impression that they're acting on behalf of the borrower. If you look at their websites, they have all kinds of information about how they are there to give the borrower their best options, and that is not being done. We're also suing for unjust enrichment. The lenders who are retaining the FFEL loans, they actually have a financial incentive to keep those loans, and they're making money off of them. So we're looking to, like you said, kind of claw that back and put that in our clients' pockets instead. And then for forward relief, we're simply looking to change the loan types, which is what should have been done years ago if the client had known to even do that. We're looking to change that so that at least going forward, we know everything's set and they know exactly what to do to get the relief in 10 years.
Yeah, because Navient and the other student loan servicers clearly aren't doing any favors for the homeowners. They're there to collect money for the student loan lenders, for their clients, presumably.
Well, that was actually Navient's exact position. The CFPB sued Navient in January of this year. And you know what Navient said in response? They said that we, borrowers, do not have an expectation that we are working on their behalf. There is no expectation for that because they believe that they're a debt collector. And they say that their only responsibility is working as a debt collector on behalf of the lender, on behalf of the Department of Ed to collect the money.
Right.
And they don't view their responsibilities to include giving the best advice to the borrower, which is something that is a problem.
Yeah, it's clearly a problem. I mean, it even could bring up some consumer protection type issues. If the borrowers are calling into Navient saying help, and Navient is really only looking out for their client's best interests and not giving the borrowers their different options, it could potentially wade into consumer protection type issues.
Yes, and in our class action, we do have account for the FCCPA, which is Florida Consumer Collection Practices Act, for that very relief. And the Department of Ed, on their websites, if you go on there, they simply say, contact your servicer. They're the best folks available for this information.
Right. So you contact your servicer, and then the servicer tries to pull some kind of, either they don't understand, or they don't know, or the people at the servicing entity don't care, don't know, whatever.
Well, one of the things that also was made known with the CFPB complaint is they alleged that Navient has a payment incentive system where they pay their customer reps more money for the less amount of time they spend on the phone. So the quicker they can hang up, the more money that rep makes. And what rep is going to take money out of their own pocket to spend extra time to make sure that a borrower properly qualifies for the relief that they're suggesting? Nobody's going to do that.
No.
And and they've incentivized that. So not only do they perhaps not spend enough time and money training their employees, they've incentivized them to not give the proper advice and not take the time to do so.
Wow. There's probably a ton more that we could talk about, but we are sort of running short on time. So I know that you want to talk about Parent Plus loans, and then I really wanted to talk to you about the Fannie Mae now has new rules about wrapping your student loans into your mortgage. However, for purposes of this episode, I think we're out of time, but here's what we're going to do. Let's do another episode. We'll record it right now. And so if you're listening when this is released on iTunes, there'll be another episode with Christie coming up real soon, where we'll also talk about those two topics, the Parent Plus loans, the Fannie Mae rules, and then I know you also want to talk about TCPA. So depending on the amount of recording time that we have today, we'll see if we can knock out all of those episodes, and I'll get them posted up here in the next couple weeks, if that's okay with you.
Sounds great.
So, but for now, we're out of time for this week's episode of the Crushing Debt podcast. So thank you, Christie. I can for certain say that we'll see you on another episode of the podcast. And that's all for this week, but we look forward to talking to you in next week's episode of the Crushing Debt podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Jesner and Jesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.